Good afternoon, everybody. This is Bonnie Vandermeulen, Training Coordinator for Wisconsin Facets. We would like to welcome each of you today to our Wisconsin Facets webinar entitled Legal Options for Decision Making at Age 18. Our presenter today for our webinar is attorney Victoria Davis Davila. She graduated from Marquette University Law School in 2011. Her practice focuses on assisting children and adults with disabilities and their families in education, family, civil, estate, and decision-making matters. Today is my great pleasure to introduce to you Victoria Davis Davila. Vicki?
Thanks, Bonnie. Well, I'm really happy to be talking to you all about legal options for decision making. It's such an important piece of the transition from childhood into adulthood. So we're going to cover a few different options today, starting with some of the less restrictive options, meaning those that allow the person with special needs to maintain their autonomy and their self-direction as much as possible, and then going forward into talking about guardianship, full guardianship, which is the most restrictive option, or it can be. So it's important to understand what happens at 18. Sometimes as parents of a young person with special needs, people assume that they'll be able to keep doing what they've been doing, especially if the child is still living with them, still going to school, planning on going until 21. But at 18, there's no, registry or way that anybody would know that your child has problems making decisions on their own, so they become their own person. That means they can make decisions on their own, whether it's about continuing school or even whether to attend school that day or sign themselves out, consenting to medical treatment, signing contracts, so signing up for that credit card or going and buying a car, signing a lease, and applying for licenses as well. So 18-year-olds have that capacity. So when a child is getting closer to 18, that sometimes families kind of go into panic mode because there's so many things happening in terms of transitioning from children's to adult services, sometimes different school systems, sometimes from pediatrics to adult medical care. There's all kinds of things. But you can really start thinking about planning for decision making. Really, it's never too early, but when your child enters the transition process through the IEP at age 14, that's a great time to start thinking about it. So in terms of making key decisions about the legal decision-making options, at 17, that is a good time to consult with the child's psychologist or doctor about his or her opinion about their ability to make decisions and what kind of options they think might work for them. But it's also a good time to consult with other people in your child's life about supports that they need to get ready for adulthood. A lot of 18-year-olds with or without disabilities aren't ready to go out into the world and make these big adult decisions. So what kind of training and support is available to help get that child where you would want them to be that could help avoid the need for some of these things? Supported decision-making agreements and powers of attorney cannot be signed and executed until the person is 18 years old. Guardianship, however, you can have entered at 17 and 9 months. So if that's the route you're thinking of going, it is one thing that you can have in place before the 18th birthday. What is an informed decision? What does that mean? One is that you need to be able to understand the information that's presented to you to make the decision. Then you need to be able to understand outcomes and consequences, have a way to express your decision, so that doesn't have to be, a traditional method of doing so, but you have to be able to communicate it in some way. An informed decision does not mean a perfect decision every time, or the first time, or the third time. A lot of us did not make perfect decisions or informed decisions as 18-year-olds, or much later than that in life. So it's important to remember that people with disabilities deserve that same kind of leeway to learn and make mistakes, and it doesn't mean that that decision-making authority should be taken from them. So as we discussed, there are several options for decision-making, ranging in level of restriction. So that would start with kind of informal options. A lot of people are able to manage their decision-making, and again, this is with and without disabilities, by using informal, either non or quasi-legal methods. For example, executing release authorizations. Sign a release so you can talk to the doctor, keep talking to the school. Set up your bank accounts with either a dual signature or joint accounts, so the parent or whoever the supporting individual might be can continue to have access and oversight. And a lot of times this is allowing the individual to maintain control over what is released, when, and to whom. Next would be supported decision-making agreements, which we'll talk about more in a little bit. Moving on to powers of attorney, which cover both healthcare and financial decisions. When you get into this range and your activated powers of attorney, the agent is acting on the behalf of the person with the disability. So in the first two options, the person is still making their own decisions. Now on the right side of the screen, we're getting into people acting on their behalf. Power of attorney doesn't have court oversight as a general rule and can be changed or revoked at any time. And then finally, we get to guardianship, which can be over a person or estate, which is sort of comparable to healthcare and financial under powers of attorney. Guardianship is permanent, so it lasts until the person's death unless somebody files something with the court to change or end it. And there is ongoing court oversight. So let's talk a little bit about supported decision-making first. So in Wisconsin, we have a relatively new supported decision-making law, but this concept is not new. So here's a quote from 2015. I think that summarizes it really well. People use friends, family members, and professionals to help them understand situations and choices they face. So they make their own decisions without the quote-unquote need for guardianship. And a lot of times that need is perceived rather than actual. And again, you see at the end there, it's not imposing long-term legal limitations on rights or personal liberty. So this is a great option for a lot of people. So just a question I like to ask folks is if they are already using supported decision-making themselves. And I would say, unless you are living under a rock, that you absolutely are. So some examples: Pinterest, and these are things we're doing on a daily basis. Home Advisor, WebMD, Facebook, Yelp, and TripAdvisor. So we are crowdsourcing advice from strangers, professionals, friends, family, and this is just through the internet. Obviously, there's tons of other ways we do this. But we're doing this for decisions as simple as where to go for dinner and what to order when we get there. So supported decision making, not a new concept, but the way that it has been codified into a new legal decision-making vehicle is relatively new. So we talked a little bit about informal supported decision-making. The formal option took effect in April of last year. A new law created an entirely new chapter of the Wisconsin statute, and that was passed with the advocacy of groups like the ARC and the Board for People with Developmental Disabilities, Disability Rights, and others. Wisconsin was only the third state in the country to have that made into law, and now there are, I believe, 9 or 10 states that have supported decision-making laws. So we're in the forefront of that movement. So these agreements cover decisions about some things that we think of traditionally when we think about a surrogate decision maker, so finances and medical decisions and things like that. But it also covers some things like where to live, where to work, how to get public benefits, that are not necessarily things that we see covered in these other documents. Specifically, the supported decision-making agreement has a provision about obtaining food, clothing, and shelter. So they allow for support in really everyday areas of life. The creator of the document specifies which decisions they want help with. So if you create a document and say, I am only creating this around managing my finances, then that supporter would basically have no business getting involved in any of those other decisions I just mentioned. And a person is able to have multiple agreements in place that cover different subjects and name different people. So if you have one person you'd like to help you with finances, another with healthcare, another with public benefits, you can absolutely do that. Anyone can be named as a supporter. There are some requirements, so if the person has been found to have committed abuse or neglect, either criminally or through an investigation by a county department, they are disqualified. But otherwise, you could have anyone you wanted as your supporter. It could be family, friends, professionals. There's really no limit. The supporter may not sign legal documents or bind the individual in any way. So this is not a surrogate decision maker. This is somebody who is helping make decisions. They're not doing it on the person's behalf. Finally, having a supported decision-making agreement cannot in and of itself be used as evidence that the person is incompetent. So you couldn't take a supported decision-making agreement into court and say, hey, look, see, this is proof that this person can't make their own decisions. It can't be used for that purpose. So the statute does list the things that it's the supporter's role to assist with. So gathering the information, understanding it, helping the person understand the consequences, actually communicating that individual's decision to others, and with the caveat that they can only have information relevant to making the decisions they're authorized to make. The other thing that sometimes people don't realize is that you still need to execute release authorizations to get records. So the supported decision-making agreement alone doesn't give you the ability to do that. So, for example, I've worked with a person who has speech difficulties, and his supporter is able to understand him clear as a bell. But other people who don't know him and aren't familiar with the way he speaks have a hard time understanding what he's saying. So she's really supporting him to communicate his decisions to other people. And again, that's just one example. Supported decision-making agreements, you can have any type of disability, pretty much. Anything that affects a major life activity, you can have a supported decision-making agreement, unlike some of the other options where you have to be found incapacitated in order to use them. Creating one of these, it must be voluntary and knowing. So you have to understand what you're doing, and you have to do it of your own free will. Two witnesses need to be there for you to sign it, or it needs to be notarized, or both. It can be revoked at any time. So similar to the ways you would revoke a will or revoke powers of attorney, you can destroy it, verbally revoke it in the presence of two people, or do a signed written revocation. The supporter can resign as well. They have to give notice. And then if the supporter is found to be someone who's abused or neglected or financially exploited, either elders or people with disabilities, that automatically terminates the agreement. So that is a way for people to be protected. So I am going to take questions at the end. With that, I was going to move on to powers of attorney. So we're at kind of the next level of restriction. So sometimes people are considering a power of attorney, but not sure if that is a good way to assist the person they're trying to help. So some questions that you can ask yourself is, one, is the person aware that they need help making major decisions? If not, if they're either unaware or don't acknowledge that, this can be a difficult choice because it's voluntary. So if you don't think you need it, you're not going to execute one. The next is a person willing to accept help, including from a trustworthy person? Are they willing to share some decision-making power? And then finally, are they able to understand the concept of a power of attorney? So you don't need a lawyer to draft a power of attorney for you. You can go online and print off the forms and follow the directions for how they have to be executed. However, if you go into a lawyer's office and there's questions on the attorney's side for whether the person is able to understand the powers that they're giving away by signing that document, they might not feel comfortable that the person has the capacity to execute that document. So we'll talk about financial powers of attorney first. These documents allow one person to manage the finances of another. And these terms are the same for both healthcare and financial. The creator is called the principal. The power is transferred to the person called the agent. In order to be considered capable of doing one of these, again, they have to select an agent, understand a general picture of what is their income and what are their assets. And that doesn't necessarily mean every penny coming in and out, but knowing, all right, I get Social Security, I have an income from my job, I have a checking account and a savings account, having, again, a general picture. And then, again, understanding the powers that are being transferred. Financial powers of attorney are often drafted to be effective immediately unless the principal or the creator says otherwise. So they can be drafted so that they become effective based on some future thing happening. And that could include being found incapacitated by 2 doctors. It also could include a date specific or some other type of contingency. Otherwise, they last until death, revocation, or some end date that the principal provided. And sometimes you may have heard these called durable powers of attorney. The reason that they are durable, or that they use that term, is because if the person becomes incapacitated, the document is still valid. So every adult should have a power of attorney for healthcare and finances in place, because disability is the only protected class that anybody can join at any point in their life. You never know when you will need a surrogate decision maker. Many financial powers of attorneys name the person's spouse as the agent. So, and they're effective immediately. However, they stay effective in the event you're unable to make decisions, and they can avoid the need for guardianship down the road, which is, it's expensive, it's court oversight, it's not time, it's a time suck, and it's an ongoing time suck as long as guardianship is in place. So everyone should have one of these, regardless of your age or current disability. The agent's authority, so again, this is the decision maker, lasts until they're removed. The agent resigns or becomes incapacitated. If it's a spouse, if they get divorced, that ends their authority. Or if there's a specified end date in the power of attorney. Or, of course, if the person, the creator, passes away. So this does not make you the personal representative of the estate. This does not continue after the person's death. The responsibilities of an agent under a financial power of attorney are basically to act in the person's best interest and manage their affairs the way that you would yourself, or for your own affairs. So that involves acting faithfully and loyally to them, acting with care, competence, and due diligence, and in their best interest. It's also best to keep an accounting, to only use the powers that were granted to you by the principal, and not to create conflicts of interest. Some of the specific things that an agent can only do if they're expressly given the authority to do so are to create trust, make gifts, create or change rights of survivorship or beneficiary designations. That would be on insurance policies or things like that. To delegate their authorities. So if you're nominated as an agent, you can't pass that power along to your son or daughter or your sister. You're not supposed to delegate. Waive rights to all kinds of things like a retirement plan or to inheritance or things like that. And also accessing electronic communication. So some powers of attorney give the agent power over digital assets, so emails and things like that, but that's only if it's expressly provided. The general authority, and I've got a big list here, but the general authority of a financial power of attorney basically gives them the ability to manage real and personal property and handle finances the way that the person would do it themselves. Some things I will point out is that a financial power of attorney by itself is not enough for Social Security. They have their own requirements. So when you're communicating with Social Security Administration, it's important to keep that in mind. The agent may not benefit unjustly from the principal. So they can't give him or herself an interest in the person's property, or anybody that they have to support, so their children or someone else they would have to support. And of course, that only applies when they're not a spouse and when the principal has not said otherwise. So basically, you can't become an agent for somebody and then buy their house for $1 and buy their car for $1 and take advantage of them. That would be a disqualifying action. The durable power of attorney is also used to nominate a guardian of the person or estate for yourself. So the creator is doing this nomination in the event that you would need one at some point in the future, basically meaning that your powers of attorney were no longer serving your needs for whatever purpose. So some possible disadvantages is that these can be revoked at any time. So if we're talking about an individual who is accepting of help at some points and not at others, this document could be shredded up and leave the person without a substitute decision maker really at any time for any reason. There is no court oversight generally. You can ask for an accounting to be ordered, but that's a special process. So I have seen people get taken advantage of because they named someone as a power of attorney who was not trustworthy, and they were able to empty the bank accounts and make other terrible decisions. They're not always accepted, so if the person you're trying to give it to doesn't feel that the person had the capacity to execute the document, it might not be accepted. And then they can also be challenged. So, did this person really understand what they were doing when they signed the document? Is it a valid document? A couple other financial management options, which I'm not going to spend a whole lot of time on, is a conservatorship, which is a voluntary alternative to guardianship of the estate. Doesn't require a finding of incompetence. Then there are trusts, specifically in this context, special needs trusts, and also able accounts. So these are some great ways that you can manage money that don't require a guardian. There's also representative payees. So if a person's income is going to be only Social Security or Social Security and a little bit of income from employment on the side, this is a way to manage finances without having one of these other vehicles in place. Their Social Security has their own requirements for those. So then we'll move on to healthcare power of attorney, which is we're going to have a lot of similar concepts to the durable power of attorney we just talked about, but we are dealing with healthcare. So in order to make this, you have to be at least 18 years old and you have to be of sound mind. The statute defines sound mind as saying you have not been found incompetent. So if you already have a guardian in place, you cannot do a power of attorney after the guardianship. In order to be valid, it has to be written, it has to be dated and signed by the principal or an adult who has the express direction of the principal and is in their presence, and then there has to be 2 witnesses and or a notary, and it has to be done voluntarily. Healthcare powers of attorney take effect when the person is found incapacitated, either by 2 physicians or by 1 physician and 1 psychologist. They have to personally examine the principal, and then they have to sign a written statement saying that the person is incapacitated, and that gets attached to the document showing that it's activated. Old age, eccentricity, or physical disability, either taken alone or together, are not the same as incapacity. So that's right in the statute, and it's something to remember. Why is this important? Because sometimes people say, I don't want my child to have guardianship, we're going to do a health care power of attorney. The child or the 18-year-old executes the power of attorney, and then a couple days later take it to the doctors to get it activated. Well, that's saying that they were incapacitated basically immediately after executing the document, which would raise some serious questions about its validity. Not that there are situations or never situations where that could happen, but the idea is that you create this document when you're of sound mind to do so, and it doesn't get activated until you're not. Anybody who has a claim to the person's estate can't be the one to make the incapacity finding. And it also can't be somebody somebody who works in a facility that's providing care for the individual cannot be the one to be the agent unless they're somehow related to the principal. So some of the powers that a healthcare agent has are to admit the person to a nursing home for 3 months or less for recuperative care, or for respite care, or if the document gives permission, they can admit to a nursing home or a community-based residential facility. So these 2 abbreviations I have on the screen there, that's what those mean. With permission from the principal. This is the biggest reason that when I mentioned you nominate a guardian in your durable power of attorney, the reason why that could end up happening, even if you do these documents, is because you need skilled nursing care, and you're not willing to accept it, and you haven't given your agent the authority to make that decision for you. Healthcare powers of attorney also deal with withholding or withdrawing feeding tubes. So that's an important decision as well. The duties of the healthcare agent are to act in good faith, to follow the directions of the principal, follow any living will, which is another document, also called a declaration to physicians. If those 2 conflict, the healthcare power of attorney has authority. They also deal with healthcare decisions for the principal if they are pregnant. And the healthcare agent can sign anything necessary to carry out the person's wishes. It also deals with anatomical gifts, so donating parts of your body for scientific purposes. Again, healthcare powers of attorney can be revoked at any time for any reason. So it can be destroyed. You can do a written revocation, verbal revocation in the presence of 2 witnesses, or just by executing a new document. The new one supersedes the old one. So again, if we have an issue around the person being willing to accept help or being prone to letting individuals into their lives that might take advantage of them, this can present a sticky situation. Powers of attorney in general do not Social Security, which I already mentioned, but also educational decision making. The Wiseman Center does have a sample education power of attorney, and I've included the link there. But that is a great place for supported decision-making agreements to come in to help bring in supporters to make those important decisions. So with that, we will move on to guardianship. So for any guardianship, the person needs to be at least 17 and 9 months when the guardianship is entered. So that's the day you have your court hearing. The person's need for assistance with making important decisions has to be unable to be met less restrictively and effectively. Now that supported decision-making agreements are passed, courts are specifically supposed to be looking at, did we consider that as an option for this individual? And the way that those their needs for assistance can be met are through appropriate and reasonably available training, education, support, healthcare, assistive devices, or other means that the individual will accept. So, you know, that individual accepting it is often a key piece of guardianship. If there are things that could be done to help that person make those decisions, but they're not willing to accept them, we kind of end up in this unfortunate situation. So, guardianship is court ordered, and now we're talking specifically about guardianship of the person. So when you think of that, think of it like a healthcare power of attorney plus. It's dealing with more than that, but it is not dealing at all with contracts or financial decisions. That person does exercise some rights on the individual's behalf, and they are making very important decisions for the individual. So in any guardianship, some key terms are who is the petitioner, and that means who is the person asking the court to order guardianship on this person. It could be the parent, it could be the county, Disability or Aging and Disability Resource Center filing the petition. It could be somebody else. Then there are the proposed guardians, who will be the decision maker, and the proposed ward, which is the name for the person who's under guardianship. The evidence required in a guardianship case is, at the minimum, an examining physician's report. That can be done by a physician or a psychologist. I have included a blank physician's report. It says examining psychologist report blank is the title of it in your handout. Just to give you an idea of all the different domains that a doctor is going to be asked to opine upon about an individual. So they're addressing what is the nature of the disability, how does it affect the person's ability to make decisions, their judgment, their reasoning, their attention, are they oriented, all those things. But then it also answers about their ability to exercise certain rights, a whole list of rights. It also addresses the need for protective placement. So that's when we're talking about a person needing to live in a facility of a certain size, like over 16 beds. So for a lot of individuals turning 18, protective placement is not going to be an issue, but a doctor's report does assess that. So the standard, in order for a court to be able to enter a guardianship, they have to find that because of an impairment, the individual is unable to effectively receive or evaluate information or make or communicate decisions to such an extent that they cannot meet the essential requirements for his or her health or safety. So it is a fairly high bar for a finding of incompetence. If you go through a guardianship hearing, I'm using the word incompetent, and I always like to advise my clients that is the term used in the statutes. You are going to hear it in court. It doesn't mean that your child is totally incapacitated and can't do anything. It's a legal term, but it's really hard for parents to hear, and it's hard for the person to hear themselves, because obviously it's a term that diminishes the person down to, not very much. So that is a legal term. I'm using it for that reason, but it is a something that it's difficult to hear. Guardianship deals with 4 main categories of disability. They are developmental disabilities, serious and persistent mental illnesses, degenerative brain disorders, so there we're talking about Alzheimer's or dementia, and then finally a kind of catch-all category called other-like incapacities. Traumatic brain injury would fall into that category. So I've talked this whole time about guardianship removing rights and kind of taking things away from the individual. There are 3 groups of rights in a guardianship. First group are rights that are removed in full. That means the ward or the person with under guardianship cannot exercise that right, and no one else can do it for them. Then there's a second bank of rights that can be exercised with guardian consent. So either the ward can do it if the guardian says it's okay, or they can't do it at all, or those powers are not affected. And then finally, there's the longest list of rights that can be transferred to the guardian, either fully or partially. So that means either that the guardian has full, unquestioned authority to make decisions about these different rights, regardless of what the person says, or it's partial authority. So a lot of times what that looks like is, hey, we're choosing social services providers. Here are 3 that are okay with the guardian. You, ward, you pick whichever one you want. I'm okay with any of them. So they're retaining some decision-making authority, but still the ultimate, the buck stops with the guardian. So those 3 rights that can be removed are to serve on a jury, to execute a will, and to vote in an election. So a couple of these things, 2 of the 3, are things that, are kind of defining characteristics of us being citizens. Especially the right to vote is so important. There have been studies that show that the capacity to vote is not necessarily linked to the severity of disability or the types of impairments that are associated with the disability. So I would say this is why it's important to have a doctor evaluate your son or daughter who knows the child and is going to really assess their ability to cast a vote, because this is, none of these things are, but this is one that should not be removed lightly. And really the findings are that, it's rare that someone would not have the capacity to vote. Rights that can be exercised with guardian consent is the next kind of block of rights. So first, consenting to sterilization. Sometimes parents are horrified that this is in here. I would never do that to my child. Why is this even here? A big reason it's there is because there was a period not too long ago that people with disabilities were sterilized without their consent. So that's why it's there. It doesn't mean you want your child to be sterilized. The question is the person able to make that decision on their own? If not, can they make it with guardian consent? Consenting to marriage. again, this is a huge one. Is the person able to get married with the consent of the guardian? Donating bone marrow tissues or organs, and then finally applying for licenses. A lot of times this is a big sticking point for our people turning 18 with that driver's license. But hunting and fishing are big issues as well, especially in this state where those activities are important. And as we all know, just having a disability alone doesn't prevent you from doing those things. So again, making sure that the doctor is assessing the person's ability to get a license to do that. Why is this in here? Because sometimes people are taken advantage of to get a hunting or fishing license when they didn't have the capacity to do so. Finally, professional licenses are credentials, so a lot of occupations require a license, and guardianship can interfere with a person's ability to get them. Finally, let's talk about the rights that can be transferred to a guardian. So, healthcare decisions, that is the big one. Who are the treatment providers? What is the treatment? Then there are these kind of off-the-wall things in there about participating in experimental treatment and research projects, and then it's broken down to whether the research project it will help you directly, or if it won't help you, will it help other people but not harm you? I mean, it gets very specific. It also deals with releasing and having access to healthcare records. Social services. So this is huge at that 18th birthday. What long-term care program are you going to be involved with? Family Care Iris. And then what about Social Security? Educational decisions, so keeping up with those IEP meetings, making decisions about post-secondary, working with the Disability Services Coordinator at a college or tech school, and then work as well, making vocational decisions, working with DVR. I've had a case where the guardian had to come work with the employer to say, my ward is losing benefits because you're working her too much, you're giving her too many hours, she's making too much money. It is not worth it for her to lose her benefits. You need to cut her hours back. Protected placement. So we talked about that earlier, that do you need to live in some type of facility? Advocating on the person's behalf. So that includes court proceedings. So did your ward get into trouble with the law? Did they steal a pack of gum from the gas station and now you have to deal with a shoplifting ticket? Did they get sued for something? Did they cause an accident? So advocating, standing in their shoes in those type of situations. Does not include contracts. Contracts are under guardianship of the estate. Making mobility and travel decisions, so where you're going and when, how far, what do you need in order to do that safely. Divorce. So if you retain the right to marry, do you have the ability to make decisions about divorce? And then receiving notices, getting mail, things like that. So there is, which I mentioned at the beginning when talking about the level of restriction, there are full versus limited guardianships. So in a full guardianship, any right that can be removed is removed, and any right that can be transferred is transferred in full to the guardian. Going back to that bank of rights that can be exercised with guardian consent, like marriage and licenses and things like that, those can also be removed in full. So a doctor could say, I don't think this person should get married, even if the guardian says it's okay. So that set can be fully removed as well. In a limited guardianship, the person can retain some decision-making power, whether it's in the form of giving input or choosing from among options, Or it could just be that, look, we don't have evidence that this person needs help making decisions related to hunting and fishing or choosing social services. They're able to do that on their own. They have complex medical issues that require appointment of a guardian to make sure they're addressed correctly. So the guardian's authority could be limited in that way. For guardianship of the estate, which is, again, similar to the financial power of attorney in terms of what it covers, the standard is that the ability to receive and evaluate information or to make and communicate decisions is impaired as it relates to property management or financial affairs, to the extent that they would fully or partially lose their property, be unable to support themselves, or be unable to prevent financial exploitation. The guardian of the estate provides financial support for the ward out of the ward's own income and assets, not personally. They settle claims, and they provide an annual accounting to the court. They can enter into some contracts. There are others that require special court permission. That annual accounting is a big thing. Every cent that comes in and out needs to be accounted for. For most 18-year-olds, guardianship of the estate is not going to be necessary. There is an exception for small estates that allows the person nominated or appointed as guardian of the person to manage small amounts of money. When I say small amounts of money, I'm talking about estates under $50,000. Unless the person has an estate worth $10,000 or more, or there's some special reason to do it otherwise, the court is usually not going to order a guardianship of the estate unless it's over $10,000. It could be necessary in situations where the person is on public benefits and they're unexpectedly coming into a sum of money that could affect their benefits. For example, inheritance or receiving a settlement, or some other type of unexpected money. So it could be a large back payment from Social Security. It could be receiving a pension payout from a deceased parent, something to that effect. And that requires special court oversight. In a guardianship, there are sometimes at a guardianship hearing many lawyers in the room. So a guardian ad litem is appointed. That is an attorney who represents the individual's best interests. It's their job to meet with the ward, advise them of their rights, and report to the court on the suitability of the guardian, the people who are nominated to serve as guardians, and whether the whole thing is in the person's best interest. There can also be an advocate or adversary counsel, which is an attorney who, if the person objects to the guardianship, it's their job to make that person's case for them to fight the guardianship. And there also could be corporation counsel involved, which is the lawyer for the county. Sometimes the county files the guardianship. Sometimes they're involved because of protective placement. It just depends on the circumstance. In any case, and then there also is sometimes a lawyer for the petitioners. It is possible to petition for guardianship on your own without an attorney. I do not recommend it, and people are always saying, well, you're an attorney, of course you're going to say that. I see attorneys who don't specialize in guardianship mess up guardianships all the time. There are some pretty technical requirements related to who gets noticed, when they get noticed, timing, things like that. And it's very easy to make a mistake that could wind up with the person who needs a decision maker not having one, or not, not having one when they need it. So I have included some resources. This Marquette Volunteer Legal Clinic is specifically in Milwaukee County. If you come with the doctor's report already completed, they can help you draft all the documents that you need to file a guardianship, but they do not have ongoing legal assistance. Some counties will file guardianship for a person turning 18 if the person doesn't have a lot of assets. I know one county in particular, it's 5,000 or less, they'll file it on your behalf. That's a good option. Remember, the county doesn't represent you, the parent, they represent themselves, so you may have disagreements on specific aspects of the guardianship, but that's something to keep in mind as well. I've also included some resources. So the Guardianship Support Center, which is run by GWAR, they have great resources about guardianship in general, or if you are a guardian and you have questions about how to do your job, excellent resources available there. I've also included the National Center for Supported Decision Making. So if you know somebody in another state and they don't know, is this an option for me? You can find that out there, plus there's tons of resources. The ARC of Wisconsin, I think, is, well, probably the best source for information on supported decision making in our state. So there's a link there. They have a great webinar that you can watch and handouts to download. And then I've also included the advanced directives form from the state of Wisconsin. So that's where you can go on and print out a power of attorney, healthcare or financial. And on the ARC's website, you can print out a supported decision-making agreement. The Board for People with Developmental Disabilities has that as well, which I believe is wbpdd.org. That's another great resource. So with that, I will move on to any questions about any of these decision-making options.
Well, we do have a shortened amount of time left, but I do have a couple of questions for you, Vicki. One question that someone asks is that many people have informal agreements with supporters or agents. And do you suggest putting those informal agreements in writing by using this new law at this time? Do you think people need to do that?
Well, I think it would depend on what your informal agreement said to begin with. And it might not be necessary if you've already got release authorizations and things like that in place. That said, if the supported decision-making agreement does the same or similar functions to what you had informally, now it's a statewide recognized thing that offers protections to the creator, I would say go for it.
Okay, thank you. There's another question about special needs trust and how to interface a special needs trust with the new supported decision-making law. Is there something that someone needs to do to recognize the fact that they have supporters?
If they want to create a special needs trust,
I believe that a special needs trust already exists, but they said too that this person also has additional, quote, supporters. So is there something you need to do to write into the special needs trust that there are others that are responsible for helping out with the decision-making process?
Sure. And I think for special needs trust, you're going to have a designated personal needs advisor or a specific person that is helping get distributions from the trust. So in that case, those are the trust rules, and that would, so just the fact alone that people have named people in the supported decision-making agreement wouldn't necessarily give them authority to interface with the special needs trust. So if it's a self-settle or a standalone trust, where an attorney has drafted it, there may be ways to bring other people into that decision-making circle. But if it's one of the pooled trusts, like Life Navigators or WISPAC, they have their rules for who is the liaison, and that would, I think, supersede the supported decision-making arrangement. Does that make sense?
Yeah, thank you. I think that those are the two questions that I have for you right now. Since we're right at the 1 o'clock hour, is there any concluding remarks that you might have, Vicki?
I have my contact information up here, so anyone who would like to reach out, feel free to do so. But I would just say that decision making is an essential part of a successful transition to adulthood, and sometimes it's something that gets put off or not given priority, and I think that it's something that we should talk about. We should include our children with special needs in as equal partners to the extent possible, and try to be as creative as we can to let people with disabilities retain their rights to the maximum extent possible.
Okay, well, thank you very much. I know that I learned a lot from your presentation today, Vicki, and I am sure that the others that participated did as well. This concludes our webinar. We'd like to thank everyone for joining us today. Please be reminded that Wisconsin Facets has over 80 scheduled trainings and webinars for 2019. Please feel free to check our website calendar and register for any of the upcoming trainings that might be coming your way. And also please watch for the short evaluation that will be coming your way after the live webinar concludes today. Again, thank you, Vicki, for your presentation today. And thank you, everybody, for your participation. Have a great day, everybody. Bye-bye.